Purple Tree Crew, connecting people, building communities, helping clients to build multi-generational wealth through real estate.
So, Bobby, we also hear a lot of landlords wants to have a key deposit, security deposit for any damages to the property. Is that something that would be enforceable?
Security deposits in residential leases are not enforceable. It's not permitted under the Act. A key deposit is, but the key deposit has to be the reasonable value to replace that particular key. So it can't be something exorbitant. And, sometimes for, if it's a condominium, those keys may be more expensive, especially the fobs, they could be more expensive. So it would have to be the reasonable value, the reasonable replacement value for that particular key.
Okay. So what kind of deposit would be enforceable?
Only last month's rent. You could only collect last month's rent. So anything beyond that is not permitted under the Residential Tenancies Act.
So for last month's rent, we had a situation where the tenant actually did not make a payment of the rent for a month, saying that she wants the last month rent to be applied for the month rent that she was late, and then she would pay it later on when she has the money. Is that something that is common?
No, it's not common, and contractually, I don't believe that would be permitted. The tenant can't unilaterally seek to have last month's rent applied to a rent during the term that they've missed payment. Unless the landlord agrees to it, the tenant would not have the unilateral right to make that change.
So if, let's say, the tenant does not pay the rent and uses the last month's rent for that late month payment, can the landlord send the Form N4 as just a way of protecting himself or herself?
Yes, the N4, which relates to a notice for failing to pay rent in accordance with the lease agreement. That is the lease that you would provide to the tenant if they miss rent, and they miss their rental obligations in accordance with the lease agreement.
What if the last month rent is not paid? Can the landlord keep sending the Form N4 every month till the last month rent paid?
The last month's rent? I mean, usually you would collect the last month's rent when you sign the lease, right?
I know. So the last month rent was used for one of the late payments. So if the tenant is always behind of 1 or 2 months, can the landlord keep sending that Form N4 till he collects or she collects the money that is really past due?
Yes. So any rental obligation that the tenant fails to follow, you can provide a notice, and you should actually provide a notice to the tenant to document, everything. And so when you attend the landlord and tenant tribunal, there's a clear record of notices being provided to the tenant.
Okay. Yeah, we see a whole bunch of situations nowadays, honestly, Bobby. So another situation that we would like to know about the landlord, actually, whether they can put restrictions or impose restrictions on number of visitors. We have had clients that, let's say, it was only a wife and the kid, and then husband joined or sister joined. Is that enforceable? Can landlord create restrictions?
No. Visitor, certainly no. The tenant has a right to have, as many visitors as they, see fit, unless it creates an unsafe health or fire risk. In that instance, then you can obviously restrict visitors. But, visitor is not someone who's living there permanently. So from that perspective, the only way you could actually create a restriction is if it creates an unsafe health or fire risk.
Okay, so if let's say it's a two-bedroom unit that is literally 600, 700 square feet, and somehow there are few people living in that unit without the landlord's permission, would that be something we can say that is definitely causes hazard?
I mean, first you would have to see what the lease agreement says in terms of who was named on the lease agreement. And so are these individuals living there permanently, or are they there for a temporary period? I think that's another factor that needs to be assessed. Mm-hmm. But if they are living there permanently and, if it creates an unsafe health or fire risk, then yes, certainly the landlord can apply to evict the tenant in that instance.
And what would be considered temporary visit? How long would
I would say anything sort of less than 30 days. 30 days or less would be considered temporary, but it really depends on the factual matrix, and every case is decided on its specific facts. But typically what we see is less than 30 days is considered temporary or a visitor.
Excellent. Thank you, Bobby. So regarding rent collection, as we actually will help renters and landlords, we see some tenants are newcomers, or they have just come to Canada as a student with a student visa or just new job opportunity. They don't have credit history, and they are willing to pay the rent upfront because of lack of credit history or income opportunity. Is that possible? Is that permissible?
Yeah, so that's an interesting question. I actually had a similar case, and in this particular case that I had, the landlord collected 6 months rent up front. It was done voluntarily. It was indicated that it was paid voluntarily. But, the tribunal, I guess there was a caveat. So the caveat to this particular scenario was the 6 months of rent that was collected, it was applied to the last 6 months and not the first 6 months. Mm-hmm. And so because of that, it became even a little more trickier because the landlord was providing notices to the tenant in month 2 that you haven't paid rent. And the tenant's position was, well, I paid you 6 months up front, so I don't need to pay right now. But the lease clearly stated that the rent payments, the 6 months, was applied only to first and the last 5 months. So in that situation, the court disagreed. It really turns on the facts. Again, it really needs to be clear that this was a voluntary agreement. And the best way to make sure that the tenant understands its rights and its obligations is to send them to a lawyer and make sure they get independent legal advice. In this instance, a realtor the tenant was being assisted by a realtor, and then the tenant made a complaint against the realtor after. Because of this issue. She said, I did not know of this term. I had no obligation, had no intention to pay 6 months up front. And so, the court decided in favor of the tenant.
Interesting. So if, for example, there is legal advice would really protect everybody, the landlord, yes, the tenant, the realtors, who can just make all informed decision. That's the reason, most likely, the tribunal decide of the tenant.
Exactly. Although the tenant was represented by a realtor, the tenant was claiming that the realtor never explained any of this and made a complaint against the realtor. So in this scenario, I think the best way to really protect yourself is to ensure everyone gets legal advice. That way, nobody can later make a claim that, I didn't know that I had certain rights and that I was waiving certain rights by signing this particular document.
True, valid point. Bobby, is there any other restriction that we didn't cover?
No, I think that's it. I think those were the main sort of restrictions that are most common in my practice, and sort of the mutual clients that we share. Those are the most common questions that arise for myself.
Okay, thank you, Vlad. Oh my God, thank you, Bobby. So we have another question that we would like to address, which is about the termination of the lease. Can a landlord terminate the lease early?
A landlord, yes, can certainly terminate the lease early. In that situation, the most frequent reason why a landlord terminates a lease early is for non-payment of rent. There's abandoned rental unit, agreement to end the tenancy, or there's a conversion to a non-residential use. So for any of those reasons, you can terminate the lease early. And there's probably others as well, but those are the most common that I see.
Purple Tree Group, connecting people, building communities, helping clients to build multi-generational wealth through real estate.